Creators, this one contract clause could potentially cause you to lose out on tens of thousands of dollars. I'm talking about exclusivity clauses. And I'm not talking about an exclusivity clause in a contract after you've already negotiated and talked about exclusivity with a brand and factored that into your rate. I'm talking about surprise exclusivity clauses. The brand never brought it up in negotiations, and suddenly you now can't work with their competitors for 2 weeks, 2 months, a year, depending on the category, the brands involved, and your desirability as a creator. That could potentially mean that you're losing out on tens of thousands of dollars in other campaigns. Personally, a believer that exclusivity clauses should never be a surprise in the contract. It is a material term, which means it should be discussed in negotiations if that is something that the brand is looking for. If it's in the contract and they never brought it up, it's honestly a bit of a red flag. The person you're negotiating with probably knows it's there, and the fact that they didn't bring it up is a sign that they're trying to get as much from you as possible without paying appropriately for it. So while I do think that brands should be the one to bring up the exclusivity conversation if that's something they're looking for, I also think that creators should be proactive and bring it up themselves during negotiations if the brand doesn't, because you're the one that's going to potentially lose money from having it in the contract. My name's Kate, and I'm an attorney for creators. As always, this is not legal advice. Everything that I share is for informational and educational purposes only.